pleasure to introduce Dr. Carrie Doherty, our VP of A, who will begin our welcome.
Welcome. Good afternoon, everyone. My name is Carrie Doherty, and I'm the Vice Provost for Faculty and Academic Affairs, and I want to welcome you all to the Spring 2025 Sonneborn Lecture, honoring our 2024 Tracy M. Sonneborn Award winner, Dr. Donna Nagy. To begin, I want to thank you all for attending. It is an incredibly busy time. It feels like it's always an incredibly busy time, and the fact that you took some time out of your busy day to come hear this fantastic lecture is, again, I'm so grateful for that. The Tracy M. Sonneborn Award is established in 1985 by the Dean of Faculties to honor an IU professor who achieved distinction as a teacher and as a scholar or artist. Since 2010, the Office of Vice Provost for Faculty and Academic Affairs has had the honor to continue this tradition. The award is named for the late Tracy M. Sonneborn, a renowned IU biologist who distinguished himself as both an internationally recognized researcher, a dedicated teacher, and a leader within the IU Bloomington faculty. In 2024, again, we have so many amazing faculty on our campus. We couldn't just have one lecture this year. We had to have two to recognize these outstanding scholars. The C. Ben Dutton Professor of Law from the Maurer School of Law, Donna Nagy, will be giving the lecture today. And in the fall, we had David M. Crandall, the Levy Professor of Computer Science in the Levy School of Informatics, Computing, and Engineering, and the director of the Levy Artificial Intelligence, gave the lecture in the fall. And I think David is here as well. I saw him. Yes, thank you so much for coming. So, without further ado, I want to invite the Dean to come up and introduce our distinguished professor. So, Dr. Christina Ochoa, please come on up.
I'm going to speak very, very slowly so that PowerPoint gets up and running by the time I'm done. I am so happy to see all of you here this evening. As I started to think about who would be here this evening, I imagined exactly what this is, a group of dear friends who admire and adore Donna, both admire, deeply respect, and also really adore Donna. It's such a privilege and a joy to get to introduce Professor Donna M. Nagy, the recipient of this year's Tracy M. Sonneborn Award. This award honors faculty who excel in both research and teaching, and I can think of no one more deserving than Donna. She embodies the very best of our academic community, producing, sharing, and advancing knowledge, and exemplifying the highest ideals of legal education and scholarship. Donna has been the pillar of the Indiana University Maurer School of Law since 2006, serving as the C. Ben Dutton Professor of Business Law, and for over a decade, she has also served as the Executive Associate Dean. She is, without question, one of the most respected and beloved members of our faculty. Her dedication to her students is legendary. She teaches not just law, but integrity, intellectual curiosity, and the importance of thoughtful, ethical decision-making. Her students leave her classroom not just better lawyers, but better citizens. But Donna's influence extends well beyond the law school. She's one of the nation's foremost experts in securities law and government ethics, and her scholarship has shaped legal doctrine, informed public debate, and influenced national policy. Her groundbreaking work on congressional ethics has helped illuminate the ethical and legal responsibilities of those in public office, particularly regarding the intersection of personal financial interests and the public trust. In a democracy that depends on transparency and accountability, Donna's scholarship has never been more relevant than it is today. And while we feel pressures against the type of work to which she has been committed her entire academic life, that truth holds still. Her impact on U.S. institutions is undeniable. She has testified before Congress on insider trading laws and on the ethical obligations of public officials. She has provided expert analysis on stock trading reforms for lawmakers. Her articles, such as Insider Trading, Congressional congressional officials and duties of entrustment, and owning stock while making law, an agency problem and a fiduciary solution, have changed and challenged and advanced our understanding of government integrity and the rule of law. She has, quite literally, helped define the legal and ethical standards that govern those entrusted with public service. And yet, despite her many achievements, what truly sets Donna apart is that she has all of those achievements and also an unwavering commitment to service, both to our law school and to the broader legal profession. She has been a guiding force in shaping our academic programs, mentoring faculty and students alike with extraordinary generosity. It is fair to say that everyone in this room has learned from Donna. She is the colleague who always takes time, the professor who always listens, and the leader whose steady hand and wise counsel have helped navigate our institution through change and challenge and continue to do that. Her contributions are not only intellectual, but also deeply personal. It's hard to think of anyone whose efforts are more woven into the fabric of our community. Donna is a mentor, a leader, and a friend. She has guided generations of students and faculty, always with wisdom, warmth, and generosity. Many of us in this room have benefited from her counsel, from her insight, and perhaps most of all, her creativity and her kindness. She has set a standard for excellence that we all strive to meet, and our law school is immeasurably better because of her presence. Again, it is impossible to overstate the impact that Donna has had on our students, on our institution, on the legal academy, and on the ethical foundations for our democracy. Please join me in congratulating Professor Donna M. Nagy, a truly extraordinary teacher, a wonderful scholar, and the best of friends on this well-earned honor.
Well, I could have done the opening even without my slide, because it's just a tremendous privilege to be honored with the 2024 Sonneborn Award. I'm overwhelmed by the introduction that my dean and my good friend Christy Ochoa started us off with. I'm grateful to Christy and to Professor Deb Whitus, who's here as well, who put forward my nomination, and to the Maurer Law grads and colleagues at other law schools who wrote letters on my behalf. I'm also very grateful for the support and encouragement I've always received from my family, especially my husband, Brian Lewis, and my daughter, Caitlin Lewis, who are here today. I'm truly touched to see so many of my colleagues and current students at Maurer Law and elsewhere on campus, including many of my counterpart administrators at other schools. It just is incredibly touching. And working with all of you is a great joy and privilege. And finally, I want to thank Vice Provost Carrie Doherty and her staff in the VPFAA's office, especially Cindy Broderick, Rachel Johnson, and Mallory Nassel-Rode, who arranged today's events. And then a special thank you for the AV people that got these slides working. So here we go. Okay. So why did I choose this lecture topic about what corporate law can teach us about government ethics? It's a topic that draws in several of my overlapping research projects and public service activities for about the last 15 years or so. And so we're going to go a little back in history here. It involves timely issues of national significance. As I was walking over here, I was getting feeds from my phone explaining the ethical issue literally du jour. And finally, it differs from some of my other research, which is focused entirely on securities regulation and enforcement. So I brought a prop. I teach federal securities regulation, which is a subject that my students tell me we can sometimes go deep into the weeds. And so what I really did not want to do during this lecture is go deep in the weeds. I really wanted I was so generous of the folks outside of the law school to come that I really wanted to hopefully talk and teach a little that will be relevant. So, okay, so my 30-year career as an academic has been spent on corporate and securities law. Before that, I practiced for a number of years as a securities lawyer in Washington, D.C. Government ethics is a field that is not really truly my field, though I am incredibly privileged to have so many colleagues here at Indiana University who are nationally known experts in the area of government ethics at large. My colleague Charlie Jay is one of the nation's leading authorities on judicial ethics. My colleague Dawn Johnson just spent the last 4 years in the Office of Legal Counsel working for the Justice Department and actually dealt on the front line with many ethical issues in the Biden administration before she's returned to our faculty. We have experts at the O'Neill School for Public Affairs. We have our political science department, has wonderful scholars who teach and write in the area of government ethics. And then, in 1977, Congressman Lee Hamilton, who's now a professor of practice at the Hamilton Lugar School, he headed, when he was serving in Congress, the Task Force on Financial Ethics in 1977. His work led to the Ethics of Government Act, which was post-Watergate, 1978 passed and signed into law. And so I'll be talking a little bit about that. So Indiana University has much to claim in the area of government ethics. My intersection and my subject of the talk is going to be in that little pink area. The overlapping, no lectures worth giving without at least one Venn diagram. And so the overlapping area there is where financial investments, which are regulated as securities, which corporate law certainly knows lots about, intersect with government ethics. And as I said, for the last 15 years or so, I have actually been researching and writing in that area. So today, I'm going to talk then about two particular areas where corporate and securities law relate to government ethics. The first is the insider trading area, using non-public market-moving government information, I know that's a mouthful, for personal profit. And then I'll also be talking about conflicts of interest, holding personal investments in entities that are directly and substantially affected by one's government actions. In some ways, one could think of insider trading as the consummate conflict of interest, but I'm going to talk about this as two discrete areas. And I also then will start out with a little bit of the sort of retrospect history. So, October 11, 2010, I was sitting in my office, minding my own business, reading my Wall Street Journal with a cup of coffee, and a headline on page 1 of the journal catches my eye. And that's the headline that says, "Congressional staffers gain from trading in stock," reporting that at least 72 aides on both sides of the aisle traded shares of a company that their bosses oversee. Now, this in itself was not new news to me. The Journal and other newspapers for years have been doing stories about sort of outside profits that members of Congress had made, outside profits. They beat the securities markets by 5 points, 10 points. So it wouldn't have been totally surprising that congressional staffers as well. The inference in those articles was somehow that there was something nefarious there, that they were using their government service learned knowledge to profit in the stock market. Not totally clear how much of a problem it was. So that wasn't what caught my eye. What caught my eye was the claim in the Wall Street Journal article that even if legislative officials had profited from trades, it would be legal, says the Journal, because insider trading laws don't apply to Congress. So my reaction was, because I've been teaching securities regulation at this point for 15 years at least, and it's like, that's not what I teach my students. So then the next day, the Wall Street Journal does another article, this time talking about a lawmaker congressman out in Washington State who was introducing legislation, the Stop Trading on Congressional Knowledge, the Stock Act. And we were going to outlaw trading on Capitol Hill as the Wall Street Journal headline. Well, now the claim was new legislation is necessary because Congress is immune from insider trading law. So then my reaction was not, it was because I was steamed at this point. Why? And so here I'll start and teach you a little bit about federal securities regulation. So as all of my students for the last 30 years can tell you, Congress has never enacted any law that explicitly prohibits anyone from purchasing or selling securities on the basis of material non-public information. This stands in contrast to most other countries with developed securities market, which ironically enough sort of look up and aspire to be the United States in enforcement of the federal securities law. But they went about so directly, that is, their legislatures defined insider trading and then explicitly prohibited that. We have not done that here in the United States. Instead, in the United States, it's federal securities regulation. The insider trading prohibition arises under the broad anti-fraud provisions in the federal securities law. Well, what does that mean? Well, Congress in 1934 gave the SEC rulemaking authority to prohibit fraud. And then in the 1940s, the Securities and Exchange Commission adopted a rule that broadly prohibits fraud in connection with the purchase or sale of any security. So that's Rule 10b-5. So here's a little more federal securities regulation. In the United States, unlike all those other countries that define the offense of insider trading, in the United States, insider trading is illegal only insofar as it can be deemed a securities fraud in violation of Rule 10b-5. So that's the name of the game here in the United States, is you have to identify the insider trading that took place as some type of security fraud. Now, Congress or the SEC didn't define what fraud is, so that falls on the courts. That falls on the Supreme Court. That's decided 4 insider trading cases over the last 40 years or so, and then the circuit and district courts that have decided literally hundreds of cases determining what is or is not fraudulent insider trading. So, the federal securities laws and courts in interpreting what is fraud under the securities law look to the common law. And under the common law, fraud typically involves misrepresentations, that is, lying about a material fact, an important fact. But the common law also tells us that non-disclosures can also be fraudulent when a person who is under a duty to disclose remains silent about a fact that would be material to a business transaction. And that is what insider trading is. It's not lying, it's keeping silent about information that one knows, the market doesn't know, the trading parties don't know. And silence is not going to be golden when there is a duty to disclose, a fiduciary type relationship. So the Securities and Exchange Commission charges insider trading as a civil offense and typically seeks monetary penalties. The Department of Justice can also bring actions criminally, and when they do, they often seek prison sentences there. So now we're going to talk about what corporate law has to do with insider trading. So in corporate law, it's considered a deceptive breach of fiduciary duty. And therefore, because it's deceptive, a fraudulent act when officers, directors, or other insiders of a corporation secretly use the corporation's information and trade in the securities that their company issued. So a board member cannot run out of that boardroom when they learn bad news about the company and sell off all their stocks, because they would be defrauding the shareholders, and they also would be misappropriating that information from the corporation itself. And so, a little bit of corporate law, public policy will not permit an employee occupying a position of trust and confidence to abuse that relationship to its own profit. So that goes back to the 1940s, the Delaware Chancellery decision. Well, under federal securities regulation, it extends beyond that boardroom. It extends beyond the insiders of a corporation who are buying the stock of the corporation. For the last 3 decades or so, the Supreme Court has said it applies to anyone who uses confidential information in violation of a duty of trust or confidence owed to the source of the information. So the securities fraud is going to the source of that information. That could be a corporation, but that could also be anyone who entrusts someone else with important information. So here, very quickly, is just some examples that, so one recent one, a husband overhears wife on the phone during COVID. Actually, she was working remotely. She's a VP official. She's discussing on the phone highly confidential merger and acquisition information. The husband secretly purchased the stock in the target company, so not even her employer, profits $1.7 million. The fraud is on his wife, or actually now his ex-wife, in violation of Rule 10b-5. So the husband pleads guilty, forfeits the profit, and is now in prison for 2 years. And I'm not kidding, actually. I mean, this broke up their marriage as well. So that's it. So it's not, though, millions of dollars. An electrician in the 1988 is repairing wiring in a company's workplace. He overhears information. He runs out and buys stock. He doesn't go to prison. The Securities and Exchange Commission brings the action. He has to give back his profit, and he also has to pay a penalty. And the last that I chose, as I said, there's hundreds of cases. That's what we would have done if my PowerPoint hadn't worked. I would just start telling you facts. So a chemist at the FDA profits $3.7 million. So this is a government official by trading pharmaceutical stock. And so he's going to prison for 5 years. Okay. Are members of Congress differently situated? Well, here we have another claim. The claim being that members of Congress are sui generis. They are elected officials who are neither employees nor agents of the federal government. Well, the legal term, in my opinion, is hogwash. Remember the slide. Public policy does not permit a fiduciary who occupies a position in trust of confidence to abuse that relationship. Well, where do I get the trust and confidential nature of lawmakers? Well, we need only turn to the Constitution. The U.S. Constitution makes multiple references to members of Congress being in positions of trust. If an electrician who is repairing wiring in a company is in a position of trust, surely the lawmakers that we send to Washington, D.C. are similarly situated and not sui generis. Members of Congress also take an oath of office where they promise to bear truth and faith and allegiance and swear to faithfully discharge the duties of the office. To me, that is certainly, if not a legal fiduciary, certainly falling within the paradigm of trust and confidential relationships that should give rise to a disclosure duty if they secretly use non-public information for personal profit. So I wrote a law review article. So insider trading, congressional officials, duties of entrustment. And basically in that article made the claims that I'm making here. Now, the other thing the article did, though, because at the time folks were like, well, the SEC or the Department of Justice have never brought an action against a lawmaker. Well, the second part of my article then talked about the enforcement hurdles that are there. Both the political hurdles, the fact is that the Securities and Exchange Commission gets its budget from lawmakers, and so there has to be maybe some bias there in the opposite direction. But even if there is, dogged enforcement, the Constitution does have a clause that actually comes into play here. It's not an immunity from insider trading clause, there's no such thing, but the speech or debate clause in the Constitution protects lawmakers from being questioned by another branch of government. The Securities and Exchange Commission, the Department of Justice, is another branch of government. So while if insider trading was occurring, that would not be protected under the clause. Getting the evidence to show that a member of Congress actually learned information and it was material would involve subpoenas for emails and documents and testimony, and that would be very difficult. So there was certainly some hurdles there. Well, you can write as many law review articles or op-eds, as I did some of that. 60 Minutes in November of 2011 does an expose on congressional insider trading. And there we have the canard again. The practice is perfectly legal, but some say it's time for the law to change. 3 weeks later, so the law, the Stop Trading on Congressional Knowledge Act, had probably a dozen co-sponsors leading into the 60 Minutes episode. After the 60 Minutes expose, lawmakers could not sign on to the bill fast enough. And so 3 weeks after 60 Minutes, there were hearings in the Senate, there were hearings in the House. I had the privilege of testifying at both and sharing my research. The Stock Act then passed. I mean, look at that margin. 417 to 2 in the House, 96 to 3 in the Senate. Signed into law by President Obama in April. And so just really quickly, I'm going to next. So I testified. My testimony was much like I shared with you. This isn't needed. What we need to do is actually enforce existing law. We really don't need another law. But so we now have in the federal securities laws, so in here, is a provision telling us that members of Congress owe a duty arising from a relationship of trust and confidence vis-a-vis the information that comes to them in their public service. So we amended the federal securities laws to tell us that. And then while we were at it, or while Congress was at it, the federal securities laws were also amended to make clear that the chemist who was already serving time in prison owed a duty arising from a relationship of trust and confidence as well. So one important but often overlooked aspect of the Stock Act. So in terms of what the Stock Act did, it made something that, in my opinion, was already illegal. It made it unmistakably, totally, undebatably clear that it's illegal. But one of the other things the Stock Act did, and this was significant, is it amended the reporting requirements of the Ethics in Government Act. So that was the legislation I mentioned that Lee Hamilton in 1978, when he was a congressman, helped shepherd through. That had reporting requirements, but the reporting requirements were annual and they were in paper, and one of the things that the Stock Act did is it put in a sort of real time, to the extent that 45 days can be thought of as real time, reporting requirement, not in terms of one's owning, but whenever one makes a purchase of a stock or a bond or publicly traded anything other than mutual funds, they have to report that in relatively real time. So it's by a transaction basis. Well, what that did then is it put a spotlight on lawmakers and their financial interests. Now, this shouldn't have been news to anyone, but the fact and the accessibility of real-time or relatively real-time trading information certainly made diligent journalists very interested in following. And what we saw here with this spotlight is that while focusing on the insider trading trees, where we already had a law that outlawed that, we were missing the forest. And the forest was lawmakers and financial conflicts of interest. that is focusing so intently on the congressional insider trading eclipsed what was then and still very much is the far greater and more intractable problem. And that's the widespread practice among members of Congress of holding personal investments in companies that are directly and substantially affected by their legislative activities. So here's just, so this advances to the present day. This is the Campaign Legal Center statistics here. Still, a little less than half of our lawmakers are holding publicly traded stock. And this is on both sides of the aisle. This is not a Republican versus Democrat. It turns out we have investors in both political parties and active traders in both political parties. And so this dates back to 2012, and you can sort of get a flavor. Members of Congress trade in companies while making laws that affect those same firms. Congress members back legislation that could benefit themselves and their relatives. And so here's just, this is a decade old, I'll come to the present day, but just to give you a bit of a flavor here, 30 lawmakers, they're purchasing health industry stocks when they're writing healthcare legislation. In the medical device area, we have over 100 holding substantial millions in stock. During the financial crisis, so yes, this goes back to 2008, 18 of the 60 members of the House Financial Service Committees that are voting for bailouts are holding stock in the financial firms that were bailed out. And then we see the same with respect to the Senate Armed Services Committee, millions and millions of dollars in companies under contract with the Pentagon. Now, if we move away from Congress to the executive branch, which I'll do in a moment, if there's, so we'll start with the Pentagon defense contractors. If you are an executive official in the Department of Defense, you are forbidden to own stock in defense contractors. And if you are in the Treasury, you are forbidden to own stock in investment banks and other financial firms. So why is that? Is it because our executive officials are so good-natured that they want to make sure that they divest at the mere possibility of a conflict? No, there's a federal law, 18 U.S.C. 208, that makes it a crime for any executive branch official, except for the president and vice president, but any other executive branch official who participates personally and substantially in matters affecting their financial interest. And so that's why the executive officials do not, and often, as for Senate confirmed appointments, the senators sit down with the secretaries of the departments and make sure they're going to be doing divestment. And I'll talk about that in a moment. So let's talk about judges, though. The judicial branch, they have their own anti-conflict statute. That then mandates refusal in specified circumstances whenever a judicial official, including a Supreme Court justice, but judges and magistrates as well, has a financial interest in the subject matter. And the statute, as my colleague Professor Charlie J can tell us, defines financial interest broadly to mean ownership however small, meaning one share of IBM means you as a judge can't sit in a case that affects IBM. Now, those are the laws on the books. So there's also law in action. And, you know, here, if we go back to the executive branch, you know, in the 3 weeks of our presidential administration, we see some action, we see some inaction. So on the action side, Howard Lutnick, who has 700 billion, I think, million shares and ownership interests in companies, has agreed, so he's the Secretary of Commerce designee, he has agreed to divest. That is now memorialized in an agreement. Scott Essett, our incoming Treasury Secretary, he has, or promises, both of them within the next 90 days from when they take their position, they've promised to divest, showing that the law on the books sometimes can have some law in action. On the other hand, 17 inspector generals, which are the officials in the agency who enforce 18 U.S.C. 208, have been terminated. And so we will have to see how much action actually occurs with respect to the executive branch. The judicial branch, judges are subject to disqualification. If you're a Supreme Court justice, nobody sits above you. So that we don't see very much action there either. My point, though, is that in order to have law in action, we need law on the books. And with respect to Congress, we don't even have law on the books. The blatant financial conflicts of interest are permissible because the prohibitions for the executive branch officials and judicial officials do not apply to congressional officials. And so while years ago everyone was running around about the insider trading immunity, the forest is the fact that there is no law currently that prohibits this. Now, I should say and must say that both the Senate and the House have ethical rules that prohibit members and their staff from deriving personal financial benefits from the use of their official position. But long-standing interpretations of those rules allow lawmakers to work and vote on legislation impacting their own personal investments, provided they are not the sole beneficiary. So if you're on the Senate Telecommunication Committee and you own stock in AT&T, as long as your vote and the bill that you introduce is for the public good, the fact that you will profit millions of dollars is not disqualifying. And just in case that was ambiguous, the Senate Ethics Manual makes this clear. So no member is allowed to knowingly introduce or aid passage of legislation, a principal purpose of which is to only further pecuniary interests or only the interests of his family. And the manual, the Senate manual, acknowledges that legislation may have a significant financial effect on a lawmaker's financial investors, but it doesn't apply as long as they also have a broad impact. This is a quote from the ethics manual. The strong presumption would be that the member was working for legislation because of the public interest and the needs of constituents and not for his own financial interests. The presumption, that's a rather strange presumption for an ethics manual, in my opinion. The House mirrors it. The House tells us that members need not divest, nor must they disqualify themselves as long as the public is generally being affected. And then just in case that wasn't clear enough, no federal statute, regulation, or rule absolutely prohibits a member or House employee from owning assets that might conflict or influence their performance of official duties here. And so, once again, we have claims. Why is Congress different? Well, the claim was that the anti-conflict statute, I shouldn't say it in the past tense, the claim is that the anti-conflict statutes that guard against self-interested decision-making in the other two branches are unnecessary because members of Congress stand for election and they're accountable to the public in a way that appointed executives and judges are not. and that mandatory disclosure of personal investments coupled with the discipline of the electoral process means that Congress doesn't need the same robust protection that we have in our other branches, the law on the books. Well, so here we go back to corporate law. Under corporate law, the corporate law of every state, directors are elected at regular intervals by the corporation shareholders. And in corporate law, courts typically apply a business judgment rule to board decisions, and that business judgment rule reflects a basic presumption that directors are acting in good faith with an honest belief. So corporate law has presumptions too. But in corporate law, the fact that shareholders elect directors is not viewed as a sufficient check on self-interested director decision-making. And as my corporate law colleagues can tell you, interested director transactions stand out as a fundamental exception to the business judgment rule that would otherwise protect decisions from second-guessing by courts. So when a board member is self-interested into a decision, there has to be certain cleansing devices, a vote of all the shareholders, a vote of all the disinterested directors, or an entire fairness test. There's no presumption that the directors are acting in the best interest of the shareholder. In fact, it's flipped. You don't get the protection of the business judgment rule. But the House and the Senate Ethics Manual essentially have a reverse business judgment there. And so, remember our corporate law here. Fiduciary relationships involve multiple components. They involve a conflicts component. That's what requires our ethics officials. That's what requires our executive officials to divest or recuse. There's also an avoidance component. If you know that your job is to deal with health care and you're in the executive branch, you shouldn't be owning health care stock. But again, notwithstanding these well-accepted fiduciary principles, the internal ethical rules insulate from challenge. So I wrote another law review article, this time owning stock while making law, making many of the arguments here that I've just put out for you. And that article had several policy arguments. Even if a lawmaker's stock trading is permissible under the federal securities law, that is, even if there is no insider trading, the personal investment portfolios that are chock full with stocks and bonds contribute to a troubling, a corrosive belief that lawmakers can and do place their personal financial interests ahead of the publics they serve. And so even if lawmakers are not influenced by their personal financing and sponsoring bills and taking it to committee, the ownership affects that creates the appearance of corruption. And then anti-conflict constraints are not about what actually happened. Somebody voted to give GM a bailout because they own stock. It's about what could have happened. Most concerned about what might have happened in a given situation. And so I wasn't influenced by my stock, my millions of dollars. Even if that is entirely true, who's to say that's going to happen the next time? So I proposed a law in the book solution, which I should say is not my solution. And I will, so this has actually been, so let's go here. Prior legislative proposals, dating back to 1995, I was just a little law professor then. Then Congressman Bernie Sanders introduced a bill that would prohibit members of Congress from owning stock in publicly traded companies. In 2012, when the Stock Act was being up for hearings and debate, two senators introduced an amendment that would have banned stock ownership. And the amendment was defeated because it was thought that the transparency that the Stock Act was bringing was going to be sufficient. But it hasn't been. And so the law in the book solution didn't work in 1995, did not work in 2012. I tried my hand at it. This Tom Price, he was President Trump's nominee for HHS secretary. So it seems like at the start of every presidential administration, I write an op-ed somewhere. I joined, so at the start of the Trump administration, my colleague and frequent co-author, Richard Painter, he's a professor at University of Minnesota. You may see him often on MSNBC. He was George W. Bush's chief ethics officer in the White House during that administration. And so, echoing Bernie Sanders, echoing Jeff Merkley and Cheryl Brown, it's time for Senators' House to divest in individually publicly traded company stocks. So this brings us up then to the relatively current day. The New York Times analysis finds that 97 lawmakers or their families bought or sold financial assets over a 3-year span that could be affected by their legislative committee work. And here's some recent examples there. So I took you through the 2012 example. Here's 2022. A quarter of the members of the Senate Committee on Energy, they're buying stocks in energy companies. In the House, we have 8 members investing in defense or aerospace stocks. Lawmakers here, they're owning stock when their committees are investigating the companies. And then the Stock Act, while it has put some transparency, you gotta file the forms, and turns out members of Congress aren't particularly good at filing forms. So that's 2022. So we have a slew of bills introduced in 2022, both before and after that New York Times article. That just gives you a flavor there. Yes, more congressional hearings. I had the privilege of testifying there April 7th, 2022. And then this kind of takes us right up until the present day here. Who knows? We do have a bipartisan, so most of the legislation here is bipartisan. Finally made it out in July out of the Senate Committee on Government Affairs and Homeland Security. And the 2 pictures there, that's Jeff Merkley from Oregon and Josh Hawley from Missouri. And so probably one of the most conservative senators, and so he is right up there. And so the votes are there, whether it can advance to both chambers, but it's out of committee, which is the first time that has happened in more than a decade, despite hearings there. And so Washington Post tells us in August, Congress might finally close the stock trading ethics loophole. Roll call 3 weeks ago or so. Apparently, President Trump thinks that this might actually be something worthwhile to ban lawmakers. Interestingly enough, the Homeland Security bill that made it out of committee also would require the divestiture for the president and vice president, so we can see what happens when that goes forward there. But so there we have it there. This is an issue, unlike insider trading, where law on the books would actually be meaningful. So, the devil is going to be in the details, and I should say that, crafting legislation, so I focus most of my writing on publicly traded stock owned by members of Congress, because that is kind of the low-hanging fruit. It's pretty identifiable. There'll be a couple of lawmakers who have their stock in publicly traded companies because their spouses get stock options. And so even the low-hanging fruit, there's going to be a lot of details to be worked out. Once we actually go to maybe regulating other financial investments, this has been the theory that, the farmers, what would the farmers that go to Washington, D.C. as lawmakers do with their family farms? When I was asked that question in my testimony, I said we can deal with the farmers separately. Not everybody is a farmer, and you certainly don't need to own millions of dollars in publicly traded stock in order to have interests that tie with your constituents. So if we we're so fortunate to work out the details, and if we are so fortunate to get law on the books, then there's the question of law in action, and that's going to require all hands on deck to actually enforce what the letter of the law prohibits. And so that will also remain to be seen. I started by talking about the history of the Wall Street Journal and sort of Brodie Mullins as someone who I've met and I spoke with often through those congressional insider trading years. The fact is that while the journalists sometimes are echoing back, he said Congress was immune because the lawmakers who were introducing the Stock Act said that they were immune. So I kind of threw him there. But the journalists that are there in the trenches reading these disclosure forms, I wouldn't be able to do the scholarly work I do without the journalists there. I'm not running through all the thousands and hundreds of thousands of stock trades. They are, and they're doing it with integrity, and today they're doing it with bravery. There's also wonderful government watchdogs, CREW, the Citizens for Responsible Ethics in Washington, the Campaign Legal Center, where some of my slides came from, Public Citizen. They're all running websites. They're all looking at this too. And we really also owe them a debt of gratitude as well. I didn't have your logos handy, or else I would have put them on the slide there. And then I'll end here. And so this is not my little dot diagram. I literally found it on the internet and haven't a clue who Madison McGinney is. But to me, it really resonated. For all of us here who are law professors, what allows us to go into the classroom and teach federal securities law or teach environmental law or administrative law is a common belief that the rule of law means something, that law matters. And not only does law matter, but the values about law matters, the transparency and the due process and the predictability and the stability. I honestly couldn't have designed a better graphic myself. And I hope for all of us that, as we go through the next weeks and months and years, that we all recognize that everything Maurer law does in terms of our teaching depends on the predictability and the enforceability of the rule of law. And I will end here, hopefully with a little bit of optimism. So thank you.
Thank you so much for an interesting, engaging, and entertaining presentation, so thank you. We do have some time for some questions if someone, there we go.
You've basically given generous credit to everyone and his dog except for yourself. I'd be kind of curious, you've been out there testifying and writing articles and op-eds and conferring privately with committees. Reflecting on your own involvement, I'd be curious to know where you sort of felt like you made you feel good about the contribution you made, where you got traction and where you were just frustrated.
Yeah, thank you, Charlie, and that's a very generous question. And so back in 2011 when I testified on the Stock Act, that was like a really interesting time, because when I testified, everybody in the room wanted legislation that banned insider trading for members of Congress. And so my testimony was essentially like, this is already illegal, guys. You don't really need to do this. And I tried to use the testimony to say, hey, this might be the time to actually explicitly prohibit the trading on wrongfully obtained information, and basically take members of Congress, but take the electrician and take the husband who eavesdropped on his wife, and let's explicitly ban all sorts of trading on wrongfully obtained information, misappropriated information. Well, that ship wasn't sailing for sure. The Senate committee was headed by Joe Lieberman at the time, and Susan Collins was the ranking member. And it was totally clear after the 60 Minutes episode that Congress wasn't going home for the holidays without doing hearings and coming up with a way to ban something. And so I think a contribution I made, the first iteration of the Stock Act was actually an express prohibition of lawmakers from using congressional knowledge. So, and I tried to pivot really quickly in my testimony. And in fact, the Senate and the House had their hearings scheduled 5 days apart. And by the House, I had completely pivoted. So I was no longer championing a broad prohibition. It's like, well, if you're going to do this, at least do it in a way that doesn't create a special category of politicians who are directly prohibited from using wrongfully obtained information, when the rest of us poor schlucks have to weed through the 100 cases saying whether something is or is not securities law. And I was joined in that Professor Jack Coffey at Columbia Law School, Professor Don Langford at Georgetown Law School. By the time we left and began to work with the Senate staffers, we were all trying to do this. Well, if what is in doubt is your duty of trust and confidence, then let's just make that clear. And so I can't take full credit for that for sure, but I think just basically reading the tea leaves and seeing we weren't coming out of this without legislation, and then trying to get the legislation the best that it could be. And I'm trying to do the same, as I said in my little devil is in the details. If a ownership ban went into effect for lawmakers, that's going to take some really careful knitting for sure. And I'd like to think, and I certainly offer to be available for assistance there. So thank you for the question.
Other questions?
Charlie said wonderful talk. I wonder if there are some notable gaps that still exist. I mean, you talked about senior executive officials. I assume civil servants have some sorts of restrictions. Are there categories kind of between them, for example, that might not be covered?
So actually no is the short answer to that question. And so I was talking about the senior officials because those are the officials that often, as a precondition to their appointment, they have to work out a divestiture plan. Now I should say, it's not the worst thing in the world because there's actually a capital gains tax deferral there. And so being able to liquidate all of your shares in your hedge fund and put it into a diversified mutual fund like all of us have our retirements in, and then pay capital gains later down the road or your estate, if that. But this applies to everybody. And so low-ranking SEC members, low-ranking Department of Treasury, and actually, let's see, can I go back quickly enough to it? So 18 USC also applies to, where are we? There we go. So even special government employees. And so this afternoon at the law school, we heard a talk about DOGE and Elon Musk's efforts at efficiency. it should not be subject to questions. Special government employees, I see my former Justice Department or my present colleagues, former Justice Department officials. So this does apply to special government employees. There's some exemptions that they're entitled to when financial interests are de minimis and would not lead a reasonable person to believe that it could compromise decision-making. The millions and billions in company ownership that the current Dodge co-chairs own are hardly de minimis, and so this applies. Now again, you know, back to law in the books, law in action, but you know, this applies to the lowest level executive official as well as some of the folks that seem to be calling the shots today. So, good question, Don. Thank you. So thank you, everybody. We have one more question. I'm sure people want to.
Yeah.
What?
No, this is good.
Okay, I will end. I just want to say a special thank you again. I've had, so I'm just so grateful for everyone coming out. I've had over the course of my career the privilege, I think I've served under 5 deans, and so Lauren Rebell was the dean who hired me here at Indiana University, and then Hannah Buxbaum, who was our intern dean when Lauren left us. For Austin Parrish, I've served with him for 7 of his 8 years. I was his executive associate dean. And Christy Ochoa and I are working together, and I'm just so happy to be working with her. So Joe Tomaine hired me in Cincinnati more than 30 years ago, and so that was my first law job. He's been my mentor and my friend since then. But I have such wonderful colleagues, but I do want to just particularly thank the deans that I've worked under. Particularly those deans I've worked under where I've also been an administrator, because I would not have been able to do what I've done, or I would not be able to write what I did if they had not been supportive and flexible and willing to do a whole bunch of my work while I was away. And so I will just always appreciate that. Not everybody is as privileged to be an administrator under the wonderful deans that I have been at Cincinnati and here at Indiana. And so I want to thank you all.
I feel like we are incredibly fortunate to have you on our faculty, so thank you so very much for all of the amazing work. And I hope everyone will stay. I appreciate you all being here, but I hope we can stay and continue to celebrate Donna and have some food and beverages, and thank you again for an outstanding lecture.
Thank you so much, Harriet. Thanks for